Subscribe to get contents via mail. Purchase shorthand journals and more.
Bail ipso facto has not been defined under the Code. It is now widely recognized as a norm which includes the governing principles enabling the setting of accused person on liberty subject to safeguards required to make sure that he is present whenever needed. The justification for bail to one accused of commission or committing a crime is that it preserves a person who is under cloud of having transgressed law but not convicted for it from the rigors of detention. Section 438 of the CRPC provides for the issuance of direction for the grant of bail to a person apprehending arrest. The CRPC of 1973 replaced the old Code of 1898. The old Code did not provide for any corresponding provision to Section 438 of the Code of 1973. Under the old Code, there was a sharp difference of opinion amongst the various high courts on the question as to whether courts had the inherent power to pass an order of bail in anticipation of arrest. The predominant position was that courts did not have such a power. Subsequently, the need for various amendments to make the code more comprehensive resulted in the enactment of the Code of Criminal Procedure 1973. Interestingly, Section 438 does not expressly use the term anticipatory bail. The language instead empowers the concerned court to issue directions for grant of bail. The Law Commission of India, in its 41st report of 1969, noted that the necessity for granting anticipatory bail arises mainly due to influential persons attempting to implicate their rivals in false cases or disgracing them by getting them detained in jail. The report further noted that apart from false cases where there are reasonable grounds for holding that a person accused of an offense is not likely to abscond or otherwise misuse his liberty while on bail, there seems to be no justification to require him first to submit to custody, remain in prison for some days and then apply for bail. The report recommended that a provision be included for the direction to grant bail in such cases and that this power vests in the high courts and courts of session only. The report, however, did not include the conditions for grant of anticipatory bail in the suggested language for provision. Certain conditions that courts may include were, however, included in the provision that was enacted as Section 438 of the CRPC 1973.